Good morning, Mr. Arley. Sir, you are charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. When to do probable cause, you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 16, 2025 at 12:04 a.m., the officer observed a vehicle traveling the wrong way at Belfort Avenue in Harris County, Texas. A traffic stop was initiated and the defendant, the driver, did not initially roll down his windows. After multiple commands by the officers, the defendant finally rolled down his windows and the officer observed the defendant to make further movements as if to conceal something. The defendant did not produce his driver's license and the officer observed a strong odor of marijuana from the vehicle and his person. The officer observed the defendant to have a loaded firearm in his waistband, and the defendant stated he smoked earlier and was not the registered owner of the vehicle. The officer located in plain view, sticking out of the defendant's right pocket, a small package with training and experience is used to conceal marijuana. PC search was conducted and the officer found 3.31 grams of marijuana under the driver's seat, and the defendant admitted the marijuana was his.
Charlie, I'm going to find that there's probable cause to go forward with your case. If you run his license, see if he has
Not eligible, Your Honor.
Okay. You are not allowed to drive. I am making that a condition of your bond. I don't care what's going on in your life. If you don't have a license and liability insurance, you are not allowed to drive. Do you understand? You will be signing a promise with me. But like I said, I don't care if there's a burning building and you have to save 50 people. If you don't have a license and insurance, do not drive. I'm going to have you come up here, swear to us that you're not going to drive. Do you have the ability to hire a lawyer, Mr. Arley? Okay, I'm going to have you fill out an application. I need to know everything about you and I'll take a look to see whether you qualify. Don't pick up any new cases. Don't become a danger to my public, and above all else, do not drive. Do you understand? Okay, come on. Can you file those conditions in the driving, please?
Yes, Judge.
And without insurance as well.
Yes, Judge.
All right, the next one is on page 2. As that be.
Good morning, Mr. Saavedra.
Go ahead.
Sir, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
One moment, Your Honor, it's loading. Okay. On January 15, 2025, the officer was conducting surveillance in the Green Points area, and the officer was in an unmarked vehicle in an apartment complex and observed 18-year-old defendant join up with 2 other males, co-defendants. He had already witnessed using a firearm. The 3 males walked around the apartment complex together, and the officer witnessed the defendant being given the firearm and wave it around. The 2 other males encouraged the defendant to shoot the gun, and the officer did not see the defendant fire the weapon, and the officer maintained visual until the officers were able to detain all 3 defendants at a nearby gas station. The gun was found in the co-defendant's waistband, and all 3 individuals were placed in custody.
Mr. Saavedra, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do you understand? I'm also ordering you as a condition of your bond not to be in contact with any. Did anyone else get arrested in this case? Or is it just him? I'm ordering you not to consume alcohol or illegal drugs. I'm sending you for a test right now. You're to come back. If you fail the test, if you fail to come back, I'm going to issue a warrant for your arrest. Do you understand?
Your Honor, there's a co-defendant in court 4. The cause number is 2547734.
I'm going to send it? Okay, so let's just do this for now. Go ahead, take a seat for me. We're going to transfer your case to the other court because that's where it belongs. Okay, please. So don't worry about it.
Yes.
Morning, Ms. Levy. And you are charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 16th, 2025 at 2:02 a.m., the officer was dispatched in an attempt to locate. The officer was advised the defendant's sister was concerned for her well-being after not hearing from her. The defendant's sister stated her last known location was the Den, a bar, where she got a flat tire. While searching the area, the officer located the defendant's vehicle at the entrance of the University of Houston, and a witness was flagged down to assist changing the defendant's flat tire. The witness stated he observed the defendant as the sole occupant of the driver's seat of the vehicle, and the surveillance video showed the defendant's vehicle in motion at the time the witness came into contact with the defendant. The defendant was identified with Texas driver's license, and the officer made contact and observed a strong odor of an alcoholic beverage, red, glossy, bloodshot eyes, and slurred speech. The defendant admitted to drinking a wine cooler earlier in the day, and standard field sobriety tests were conducted. The officer observed the defendant to be unsteady on her feet as she walked to the sidewalk, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 1 out of 4. The DIC was red and the defendant consented to breath. The results were 0.185 and 0.181.
And you're telling me there's video of her driving?
Yes, Judge.
Ms. Levy, I'm going to find that there's probable cause to go forward with the case. Have you run your license and any prior DWIs?
Driver's license is eligible and no priors, Your Honor.
Okay. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you consume alcohol or illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer? Okay, I'll give you an application. I'll take a look at your numbers, and if you qualify, we'll provide you a lawyer today. Okay, just everything's fine. Don't worry. Just be safe. Okay, just don't. Okay, I don't want to talk about the case. Let's have you fill out the application, then I'll have you talk to a lawyer today. Okay, ma'am? Please.
Right this way.
Good morning, Mr. Newman. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 15, 2025, the officer was dispatched to Texas Southern regarding a male on campus possibly carrying a firearm. The caller provided the name and dispatch ran through arms and located a recent picture and a trespass notice. The officer observed the defendant walk into the library, immediately walked out accompanied by a second black male, and the officer attempted to detain the defendant, and the defendant ran northbound, ran through an apartment complex. The officer drove through the complex and set up a perimeter and observed the defendant run out of the complex. The officer exited a marked patrol vehicle in full uniform, drew a duty weapon, and ordered the defendant to the ground. The defendant ignored the commands and continued running and was assisted to the ground by the officer. The defendant stated he ran due to being scared. The defendant evaded approximately 0.4 miles.
What was he doing wrong?
So there was a report of a possible firearm on campus, and the caller provided the name, and he was attempting to investigate that, and he was just trying to detain him to
They
investigate.
give the description of him.
They just gave the name, and then they
A name
ran
of-
that through arms, and they found a picture of that person.
So the caller gave the name of Mr. Newman.
Yes, Judge. Gave Mr. Newman's name, the officer ran that name and found a picture, and then observed him leaving the library and attempted to detain him. And then he ran.
There was also a current trespass notice for the defendant as well.
Yes, Judge.
From TSU.
From the arms or TSU.
Yes, Judge. They found for TSU through arms.
Mr. Newman, I'm going to find that there's probable cause to go forward with your case. Let's do this. I'm going to appoint you a lawyer today because there's several things that we need to look at. So do you mind reaching out to the MAC for Mr. Newman? Mr. Newman, assuming we go forward with the case, you're not to be in possession of weapons. Do you understand? I'm
Yes,
making
sir.
that a condition of your bond.
Yes, sir.
If I find that you have any weapons, I'm going to revoke your bond. I'm going to put you in jail.
Yes, sir.
Just all I want is my community to be safe. I'm not asking for much. You understand? Okay. I'm going to have you sign a reset Victoria, then we'll have you take a seat in the jury box, sir. Okay?
Buenos días, nomás escuchen pues y conteste voz alta, por favor.
I don't think that, I don't know if have we found probable cause on this first case? Or I mean, on the new case? Let me express my extreme disappointment, Mr. Guevara Ortiz. You now stand charged with yet another DWI. On this one, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On January 19th, 2025, at 11:43 p.m., the officer was dispatched due to a concerned citizen. following a possible intoxicated driver. The call was near Northborough in Houston County, Harris County, Texas. The officer arrived at a public place and observed the defendant, the driver, and sole occupant of the vehicle. And the witness stated the defendant was observed to have severe damage to the front passenger side, and he struggled to stay in its lane several times. The witness had eyes on the defendant until the officer arrived, and the officer made contact with the defendant, who advised that he had 3 Coronas and was coming from a gas station where he purchased the beers while driving home.
So drinking while,
No, Your Honor, there's no indication of that. He just purchased while driving home. And the officer observed glossy eyes, delayed responses, and a strong odor of an alcoholic beverage. The officer conducted standard field sobriety tests, HGN 6 out of 6. The defendant refused the walk and turn and one-leg stand due to the cold temperatures. The defendant was read the DIC and consented to breath. The results were 0.189 and 0.177.
Mr. Guevara Ortiz, I'm going to find that there's enough probable cause to go forward with your case, and I am now going to revoke your bond on your first case, and I'm going to set it at 10,001. You now also have an immigration detainer, so you will be stuck in there, I guess, until I need to know, counsel, if you guys are planning on trying to get him an immigration bond or not.
Your Honor, we don't represent him on the immigration case, but it's my understanding from Mr. Breston that there's an effort to address that.
Okay. You're signing on for Mr. Breston now, right?
For it, yeah, I work for him. Yes, sir.
Got it. All right. Mr. Guevara Ortiz, I'm now ordering you to have an ankle monitor on your ankle, and I'm giving you a curfew of 7 p.m. to 7 a.m. I'm going to put a scram ankle monitor on you so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor. I don't know if you're getting out of custody, but if you do get out of custody, these will be your bond conditions. You will have on one ankle, like I said, a scram monitor, so I know that you're not consuming alcohol. On your other, you will get a GPS monitor, so I know that you're abiding by curfew. Do you understand?
Yes.
Okay, so I guess we'll set you out for 30 days. Just keep us in the loop. If you do, if you are able to get an immigration bond, you must be here the next business day. If you fail to do so, I'm going to revoke both of your bonds and set them extremely high. Do you understand?
Yes.
Okay, all right.
Thank you, Your Honor.
Thank you, sir. Alex, you ready?
Ready.
Let's roll, nerds. Lyra's first.
Okay.
Thank you, Your Honor. I greatly appreciate
Are
it.
you also on the co-defendants? Just Ms. Lyra? Okay. Vanegas,
Yes, Your Honor, no, Your Honor, speak up publicly.
Tristan Vanegas.
Oh, Judge, she's running late. I'm on call.
Okay. Are you or James Lyra? Mr. Lyra, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, at approximately 12:51 a.m., the officer on-viewed 2 vehicles at the block of Tomball Parkway, blocking the moving lane of traffic. The officer observed a white Jeep and an orange Corvette line up directly next to each other side by side, and the vehicles accelerated at the same time at a high rate of speed. The traffic stop was initiated of the white Jeep, and the officer made contact with the defendant, the driver, who gave his name and was identified by his Texas driver's license. The other officer stopped the Corvette and detained the second defendant. The driver was positively ID'd by the Texas driver's license.
Know how fast they were going?
Your Honor, they do not specify in the DIMS.
Okay. Mr. Lyra, I'm going to find that there's probable cause to go forward with your case. Have you run his license, see if he has it?
Eligible, Your Honor.
I'm ordering you as a condition of your bond not to participate in this kind of behavior again. If I see that you do, the first thing I'm going to do is I'm going to revoke your bond, put you in jail. The next thing I'm do, I will take your privilege to drive away from you permanently. Do you understand while this case is over?
Yes, sir.
Open. The ability to not drive in Houston blows. Trust me. Do you understand?
Sir.
Now, you have a lawyer. It's your responsibility to stay in touch with Mr. Clay, and he'll tell you when you have to come back to court. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you when you have to come back to court. You pick up a new case, you endanger my public. I only have one place for you. You understand?
Sir.
All right. So I'm going to have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
Judge, you have the excuse.
Yes, sir. Thanks.
All right, Judge, next is page 16, Johnson, Donald, come on up.
You are Donald Johnson. Mr. Johnson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to the theft of a motor vehicle at a residence in Harris County, Texas. The officer made contact with the complainant, who advised that his truck was stolen off the property at 12:42 p.m. and the complainant showed officers clear footage of the theft, where the officer observed 3 white males exiting a motor vehicle, one suspect going under the hood of the complainant's vehicle and getting in the passenger seat, and another suspect drive the motor vehicle off the property. The officer got the suspect's motor vehicle's license plates, ran that license plates through Lens, and got an address. When the officer arrived at that address, he observed the motor vehicle used to commit the theft in the driveway and knocked on the door and met with all parties inside the home. All subjects matched the subjects on surveillance, and the defendant had the same clothes as in the footage. The defendant admitted to, the second defendant admitted to driving the motor vehicle and showed where he dumped the vehicle, and the complainant's vehicle was recovered. The first defendant, Mr. Johnson, admitted to helping the second defendant steal the motor vehicle.
So you're telling me that they allegedly stole a car.
Yes, Judge.
He's charged with a misdemeanor theft, Class B.
Yes, Judge.
What is the value of the car?
According to the DIMS, the complainant advised the value was $600.
Does he make a statement that he knows the car stolen?
He makes a statement that he admitted to help steal the vehicle.
Okay. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. We do have co-defendants in this case, do we not?
Yes, Judge.
I'm ordering you as a condition of your bond not to have any contact with the co-defendants in this case and not to have any contact with the complaining witness in this case. You pick up a new case, you endanger my community, I'm going to revoke your bond, I'm going to put you in jail, and I'm going to make it extremely high. Do you understand, Mr. Johnson?
I do understand.
What do you do for a living, sir? How do you support yourself?
Sir,
How do you support yourself?
I'm trying to get disability right now, sir.
All right, I'll help you fill out an application. Do you mind giving me an application? Do not leave until you sign our bond conditions, otherwise
Yes,
I will
sir.
issue a warrant for your arrest. I'm going to give you an application. I'm going to have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
And
Right this way. All right, Judge.
So
next
can you
is
file all
page
those conditions,
16.
please?
No contact with co-defendant and complainant, and was there anything else?
Yeah, no new law violations and
Yes, Judge.
All right,
Mhm.
this way.
no weapons.
Yes, Judge.
Plan and site for the consent. Judge, this next one is on page 16, bottom of 16.
Okay,
So the DWI landed in court 3. Go ahead and have a seat in the jury box. Here you go. Landed in court 3, so they should be transferring it. On topic today is the assault family.
where's Mr. Jones? James Jones, come up.
Sir.
Do you have an arraignment? I'd like to help the lawyers. Vic, can we help the lawyers first so we can get them out?
Oh, I didn't know they were for arraignment.
Yeah. Guys, if you have an arraignment, let me know. Let Victoria know so we can get you out of here. Take a seat for me in the jury box, sir. I'd like to, can we get the case transferred so we can, yeah. And then if you want to go ahead and appoint someone for him as well, Vic, please.
Judge, do you want to go ahead and with council?
Yeah.
Okay.
With everyone. Mark,
Page 5.
yep. Oh,
Yeah,
okay.
Page 5, Sevoya, come on up.
Do you have an arraignment today?
So,
Do you have an arraignment today?
no,
Okay.
I have, well, I think I have a person who's on the docket because they had a violation on the.
Okay.
I just heard about it. She's from California, so I don't know if she's there.
Yeah.
Just, I'll circle back.
You are Ivan Shagoya.
Sir.
Mr. Shagoya, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, at approximately 4:30 a.m., the officer observed the vehicle fail to stop at a red light at the East Texas Freeway on Harris County, Texas. The vehicle would have struck the officer's patrol vehicle had the officer not come to a stop. A traffic stop was then initiated and the vehicle continued to drive 0.5 miles before stopping. The officer made contact with the defendant, the driver and sole occupant, and observed an odor of alcoholic beverage, glossy eyes, and slurred speech. Standard field sobriety tests were conducted, HGN 6 out of 6. The officer did not conduct walk and turn and one-leg stand due to safety concerns and the nearby sidewalk not being level. The officer observed a Glock 9mm in plain view from the front passenger window located on the passenger floorboard near the center console, and a PC search was then conducted. A second loaded firearm was found in the center console, and the defendant was then read the DIC and refused. A blood search warrant was signed and executed.
Mr. Shagoya, I'm going to find that there's probable cause to go forward with your case. Have you run his license?
It is eligible, Your Honor.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand? I'm also ordering you not to be in possession of any weapons as well, sir. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he can't get a hold of you or you've taken off or you pick up a new case, I will revoke your bond. Have you looked to see if he has any prior DWIs, Alex? Please.
He has, one moment, Your Honor. No priors.
Okay. All right. So for now, I'll have you sign a reset. Victoria will get you with Felicia for your bond conditions. And after that, you'll be free to go, sir.
Thank you, Judge.
Thanks, guys.
Excuse me.
Please.
All right, the next is page 17, Steve, come on up.
Good morning, Ms. Keys. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On January 18th, 2025, the officer observed the vehicle failing to drive in a single lane on West Grand Parkway in Harris County, Texas. The defendant was swerving in and out of 2 lanes and came close to crashing into another vehicle in the next lane. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The officer observed disorientation, a moderate odor of an alcoholic beverage, and slurred speech. The defendant could not provide ID or insurance, and the officer observed an open container of alcohol on the floorboard next to her feet. The defendant stated she had not consumed alcohol, and the officer observed slow movements and unsteadiness on her feet. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 8 out of 8, one-leg stand 2 out of 4. The defendant was read the DIC and consented to breath. The results were .290 and .294.
So are you telling me that she had alcohol in the car while she's driving?
There was an open container on the floorboards.
Did you put any other indicators like it's cold or?
No, Your Honor.
Ms. Keys, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand, ma'am? I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail, ma'am. No more PR bonds. Have you run her license, Alex?
I'll run it right now, Your Honor.
Please. And any prior DWIs?
There are no priors, but there is a pending one out of Austin County, it appears.
She has a pending DWI in Austin County?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine every single time. I am now going to put an ankle monitor on you so I know that you're not consuming, and I'm also giving you a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor. Stop. I don't want you to talk about the case. I can provide you a lawyer today, but if they're telling me that you have an open DWI and now you picked up another one, I have a big problem with that. I was going to provide you a lawyer today, ma'am, if you would like, a court-appointed lawyer. Did you want a court-appointed lawyer? I will provide you a lawyer today. Ms. Keys, if you have a problem with alcohol, I'm giving you the opportunity now to address it on your own. If you do not, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand, man?
Yes.
I'm going to do everything in my power to protect my public at all cost. Every single day, someone dies from a DWI in our county. I need you to fill out an application for me, or you know what? Hold on a second, maybe I have. Vic, I have an application on file already. So if you just want to appoint her a lawyer, I'm going to have you sign a receipt with Victoria. You will meet with Fleischer for your bond conditions. And after that, we'll have you take a seat while I'm your lawyer. I'm going to have you sign a reset. After that, you'll get with Fleischer for your bond conditions. After that, I'll have you take a seat while I find your lawyer. Please.
No driving affidavit?
Oh, yeah, no driving affidavit. Right.
Martinez, Shore.
So Alex, on every DWI, I need you to run the NCIC
Yes, Judge.
going on with every single person because you,
Yes, Judge.
no, it's. Vic, what page?
Page 18,
Got it.
Marquez.
Good morning, Mr. Marquez. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17th, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant had been continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes,
Is this the same complaining
Same
witness?
complainant.
Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is this a stalking statute? You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand?
Yes, Judge, the milk was signed last Friday.
Okay. So it looks like a protective order has been issued. I would get to know it because if you violate this protective order, the state can and will file a violation of protective order. That is the capital murder of misdemeanors. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was,
Yep.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay, so you don't want a court-appointed lawyer then? Okay, I'm gonna have you sign a reset. After that, we'll get with Fleischer for your bond condition. After that, you're free to go. Don't violate these conditions, Mr. Marquez. It's not gonna go well for you. Do you understand? Okay, come on.
Your Honor, no contact, no weapons.
Don't worry about it.
Yes, Judge.
He's gonna be monitored for the alcohol and dope.
Yes, Judge.
For Martinez,
PHA,
CHA, and pretrial bond condition.
Yep.
Judge, on the membership conditions as well, there's another address listed. There's two addresses listed. Do we want to keep both of them, or is only just the one on the lower?
I don't know. You guys, what say you?
I'll check the ones on the MOAP and see what we have.
For the next one.
Fernandez.
Morning, Your Honor.
Hey, how are you?
Doing great, thank you. Yes, sir.
Yeah,
I apologize. Mr. Sarmiento?
with an S?
Yes, yes.
Sarmiento, coming up.
27.
I have it listed here as Sarmiento. Is that right? Or is it Sarmiento?
Sarmiento.
Sarmiento.
Sarmiento,
Sarmiento, correct.
S-A-R-A?
S-R,
Yes.
S-A-R-M-I-N-T-O. Sarmiento.
Okay, all right. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 13th, 2024, the officer observed the defendant's vehicle traveling at a high rate of speed without a front license plate. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The officer observed the firearm in the passenger side door, and the officer asked the defendant to step out. The officer observed a firearm in the driver's side door, and both firearms were unholstered. The officer asked the defendant for consent to search the vehicle, and the defendant agreed. The officer searched the vehicle within hand's reach of the defendant, and the officer observed a Ziploc bag in the glove compartment with a $20 bill and what appeared to be small baggies with a white powdery substance inside, believed to be cocaine based on training experience. The weight was 3.77 grams.
Okay, sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do not pick up any new cases. Otherwise, I'm going to put you in jail. I don't know what your immigration status is, but if you go to jail and you spend any kind of time there, immigration, and you're not here with proper documentation, immigration will put a detainer on you. You will be stuck like Chuck in there until this case is over with and then shipped off to immigration. So beware what you do. I don't know what your status is, but if you're not here with permission, be good. You have a lawyer because you have one that will waive your appearance, but it is your responsibility to stay in touch with him. You pick up a new case, you endanger my community. It's not going to go well for you. Do you understand? And we'll have you sign your resolutoria. We will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Thank you.
Thank you, Your Honor.
Thank you.
Good morning, Mr. Paredes. You were charged with tampering with the government record with intent to make it genuine? Is that right?
I'm sorry. Say it one more time, Judge. I missed what you said.
You're charged with tampering with the government record. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officer observed the defendant's vehicle with a paper license plate on North Freeway, East Service Road. The officer ran the license plate, and the license plate came back with no record. The officer observed the license plate was a copy and did not have required security features. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The defendant stated he received the license plate from the person who sold him the truck that he receipts a new license plate whenever he makes payments, and that he thought that was legal. The defendant stated he did not have insurance on the vehicle, and the officer ran the VIN and discovered the motor vehicle to be salvaged. The officer also found the vehicle has never been registered and had never had a state inspection. The defendant provided a dealer tag receipt for the license plate, listing him as a purchaser.
So he tried to purchase in good faith, Judge. He just, I don't see how there's any criminal intent.
But he's making payments and he gets a new license plate every time he gets a payment.
That's what the officer says he was saying.
Well, right, but I mean,
Right.
Marcos, I see what you're saying, because he's charged with tampering, right? To tamper, you must, I know, let's pull the code.
Right.
Because I mean, do you have to make a willing,
But you negligently or recklessly.
an alteration, so to speak, you know? Let's see.
Knowingly makes a false entry in the false alteration of a government record.
A person commits, if he knowingly makes a false entry in or false alteration of a government record. Makes, presents, or uses any record, document, or thing with knowledge of its falsity with intent that it be taken as a genuine government record.
Your Honor,
I think that is what they're probably relying on in this case.
if I may, as the information alleges, it's subsection 6 where it possesses a governmental record with knowledge that it was obtained unlawfully. So,
Well, he doesn't know it was intended lawfully, even from.
Well, hold on. That's your burden, right?
yes, Judge, and in this case, we would show that reasonable certainty by his obtaining it every time he makes a new purchase and obtaining it from the person who obtained the vehicle rather than from the government. So it would be through that.
When I go buy a new car, though, they give me a tag. You know what I mean? So at some point, yes, you're supposed to get something like a license plate from, I guess, a state, you know, from the state authority, right? They give you the license plate, but here,
They give you the paper plate and you assume that they're gonna do all the paperwork behind the scenes. They send it to the government, to the state agency. Then the state agency sends you the metal plates.
if this had been like maybe a month or two that he purchased it, perhaps. But if we're talking that he's had this car for like a year, then I don't think that's reasonable. I don't think that's a reasonable argument to make. So,
And I don't know how long.
and
it is.
this car purchase,
Let me see, Your Honor. So the only thing in regard to the status of the vehicle is the officer only found that it was a salvaged vehicle, and he lists a date of loss as June or May 29th, 2020. So I don't know if that's when the defendant obtained it or that's just. when
no,
it was
that's just when it was salvaged at
Yeah,
that
so
time.
that's
So
the
at that
only-
point, you can't even drive the car because it's salvaged, right?
Right,
It's
and
a
that's
salvage
the
title,
only
but
date that the officer provides. So, and, you know, so with the information we
you have a
have,
copy of the tag?
let me see. So the buyer's tag lists an expiration date of February 5th, 2025, and lists the vehicle of the 2007 Chevrolet, and it doesn't
Is
list.
this, it should say like a date of purchase, right? Why don't we do this? Look,
So it says it expired February 5th, and this happened on January 16th, and I just asked him when he bought it, he said it was about a month and a half ago. And I said, how many
let's do this. Show me. Let me give you more time. Let me just do a little bit more diligence.
Okay.
All right. We'll come back, but let me burn through all this because I didn't think it was going to take this much time, but we'll revisit. Okay.
Yes, yes.
Don't worry.
Okay, 20,
Give me-
Longo.
Given arraignment? Come. So these are really, really old cases, huh?
You're super old, Judge. She had one attorney, I think it was during the pandemic that we subbed in on, and then the other case as well, Your Honor. And it was a mix of a lot of things financially and on why he was kind of MIA.
Did you represent him before?
We were on the case, we just never got off. We were on him on the assault case.
Are you wanting to stay on or do you want to get off?
We're gonna stay on, Judge.
Okay.
You just in a way rehired.
So, Mr. Montalongo, you're charged with two cases. You're charged with assault of a family member. You're also charged with terroristic threat. Both of those, you're facing up to a year in jail and or a $4,000 fine. I'm going to tell you now, you take off on me again, I'm going to make your bond so high you'll have hair falling out. Do you understand? As it stands now, your case is 1,289 days old on one. The other one is around another 2 years old as well. I'm assuming probable cause has been found already.
I would like to take up probable cause, Your Honor, on the terroristic threat one, if we can.
Okay,
Okay, go for it.
yes, Judge. On February 28th, 2023, the officer responded to a terroristic threat, and the complainant stated she is the sister of the defendant, and that prior to the day of the call, the defendant had been sending her threatening messages to her phone. The defendant sent a text saying, "I hope you take a punch to the fucking face. I'ma break your fucking face with my fist, bitch. I want to hear your bones break." The complainant stated the defendant has been verbally abusing her and has a history of assaulting their father.
Your Honor, I believe the key element they're missing in this probable cause for the terroristic threat is the imminency. There's nothing showing that this is imminent, it's about to happen, or is going to
Because I'm
happen, or
going
some
to.
future event.
I mean, I'm going to.
I'm going to, it can be very vague, Your Honor. We don't know how long that's going to be. If it's like, hey, I'm coming over right now, or if he said that in person. I think the case law is pretty clear on the imminency on that. For example, like,
You're telling me there's case law that says I'm going to is not sufficient?
I have to look at the specific words of I'm going to, but it references a future event. So if it's in reference to a future event, it's not imminent, therefore it's not, it doesn't meet the requirement.
State response?
So what we have is that they had an argument the previous night, and that the morning of the incident, that's when he sent the text saying, "I'ma break your face with my fist." So that would go towards, I doesn't really address the imminent issue, but it does address a future threat.
Montalongo.
Your Honor, I would agree with where you were going, that I'm going to, and just the overall tone of the
Mhm.
message is implying imminent and will put a reasonable person in fear.
I think so as well. Mr. Montalongo, I'm going to find that there's probable cause to go forward with your case. I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that the RIP is missing on the terroristic threat, and on the assault, it's complete.
So, okay, so I'm going to give you 30 days. You must be back at that time to figure out what we're going to do. You must either accept a plea bargain from the state, or else I'm going to set your case for trial. You understand? Okay, so if you can please put offers on both of the cases, we'll see you back in 30 days. We'll go from there.
Understood, Judge. Thank you.
All right, Judge, next is page 8. There, come on up.
Fair, you are charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival, but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2
just
co-defendants?
one.
Yeah, just the sister, Your
Okay.
Honor.
You know of alcohol or any kind of
There's no allegations, Your Honor.
See that she's on probation as well. Ms. Fair, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay, if I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. Do you understand, ma'am? Do you need a lawyer, ma'am? Okay, Ms. Fair, I need you to fill out an application for me. I'll provide you a lawyer after that. Don't violate these conditions. Do you understand, ma'am? Okay, please. We'll have you sign a reset. You'll get with Fleischer for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and
Ma'am, hold on, come back up.
he's no longer living, he still has the lease to the residents of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get a restriction, like a
Sure, just provide it to Felicia so she knows, and then we'll put that in the order as well, that she's not to go to this location.
yeah, judge.
Okay, okay, ma'am, please. You were Dedrick Addison?
No.
No, Judge, they didn't come on. Page 6, bottom of 6.
Mr. Cogdill?
Yes, sir.
Sir, you're charged with terroristic threat of a family or household member. That allegation kicks it up to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge, on March 1st, 2024, the officer is dispatched to a terroristic threat call in Harris County, Texas, and the complainant and the defendant have an on and off dating relationship. The defendant is also the father of the complainant's child. The complainant stated they got into a verbal argument and she recorded it. The officer listened to the recording and the defendant stated he was going to beat her mom up and kick the door open and kill everyone in the house. The defendant also stated he has nothing to live for.
Mr. Cogdill, I'm going to find that there's probable cause to go forward with your case. Do we know if she wants to have contact with him or not?
Let me see if a rip has been. Your Honor, there's been no contact made as of now.
Until I know that this person wants to have contact with you, I'm ordering you not to have contact with this person and not to be in possession of weapons. Do you understand? Just be good. It's not hard, you know. Would you like me to provide you a lawyer today? Okay.
All right, Judge, next counsel is here on page 28.
Mr. Downey.
Shriber.
Hi. Wow, 2 times in 1 week, huh?
Back to back.
Go play the lottery. It's Shriber?
Yes, sir. Judge,
Got
Kyle Shriber.
Come on up, Mr. Shriber. Good morning, sir. Sir, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officers made contact with the complainant at a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses. I know where you live. I got y'all." And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is.
So are they next door neighbors?
No, they
So-
live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Shriber that staying away from them is good.
Just really, that's all we're asking you to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys. Please. Give an arraignment?
Yes, it's for Blake Jenkins.
Okay.
And Judge, I showed up and he is wanting me off the case. He wants a new attorney.
Jenkins, come up,
We got that. We got the-
please. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, there was, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas
Yes,
driver?
Judge, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to address that.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the lawyer.
about my two cases before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today. I'll give you a lawyer, another. If you want to get off, and I'll provide you another lawyer. It's the 3rd case. Unacceptable. Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 18, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are 2 very different things with 2 very different distinct smells. Additionally, if the officer is pulling them out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell-proof. In this instance, I think we have an officer who went too far with the search because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute,
Mr.
of
Johnson.
course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is
I
identical to
understand, and that,
marijuana.
yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, you know? So
I understand.
I'm gonna find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car.
Yes, Judge.
I'm now revoking your bond. Goes with you. Sorry, Sean, but you know, he promised us he's not gonna drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm gonna do it at 5,001.
Okay. So first case, 5,001, and then the new case, of
I'll
course, would be
leave
bonded
the
out
first
as.
one, or the second one as is, though.
Which case number?
So the one that's on page
14 or 13?
14, that one gets revoked to 5,001. Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On January 16th, 2025, at approximately 10:25 p.m., the officer was traveling on East Sam Houston Tollway and observed the vehicle traveling at a high rate of speed, overtaking other motorists and changing lanes without signaling. The officer observed the vehicle get on Ship Channel Toll Bridge and pace the vehicle at 75 miles per hour in a 50-mile-per-hour zone. The vehicle further failed to drive in a single lane, and a traffic stop was initiated. The officer made contact with the defendant, the driver of the vehicle, and observed the defendant to have slurred speech and odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and refused to provide a specimen, and a blood search warrant was signed and executed.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything of this nature, I'm going to revoke your bond, put you in jail. Do you understand, ma'am?
There's no driver's license on file for the defendant.
Okay. Any prior DWIs?
No priors, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I take it extremely serious. You just saw what happened. If you don't have a license and insurance, do not drive. Would you like to apply for a court-appointed lawyer, ma'am? Okay. What's going to happen now is I will have you swear to it that you're not going to drive without those two documents. I will have you sign a receipt with Victoria. We will have you get with Fleischer at some point for your bond conditions. In the meantime, we'll have you fill out an application, then I'll have you speak to a lawyer here momentarily. All right? Please. Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have
Judge.
the right to have an attorney present. If you're not afford one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended their relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no caller ID. The defendant spoke to the officer and admitted to calling the complainant 100+ times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. Do you have the ability to hire a lawyer, Mr. Humphrey? Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on.
Next judge is page 21, Montes.
Jesus Montes, you speak English, sir? Come on up. So I've got Mr. Cedillo here on an arraignment with Gibson over there. We can do that next. You are Jesus Montes. Mr. Montes, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer met with the complainant who stated that her and the defendant are married, and while at the defendant's sister's home, they got into an altercation. The complainant stated that the defendant grabbed her by the neck and pulled her hair, causing pain. The officer observed redness to the complainant's neck area.
Mr. Montes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. There is a protective order that has been issued in this case. I would get to know it. If you violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. You understand? Do you have the ability to hire a lawyer, sir? Okay. We'll provide you a lawyer today, but don't pick up any new cases. Don't endanger my public. You understand? I'm going to have you sign a receipt of Victoria. We'll have you take your seat in the jury box while we get your conditions. We'll have you sign it, and then we'll provide your lawyer here momentarily. You were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 2020.
Hold on.
Yes, Judge. Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back 2 metal sheets that lead to 2 large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again?
The complainant filed a civil lawsuit against the defendant for not paying rent, and that the complainant was there to obtain property. or the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how the how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay, we'll take a
I
look
mean,
at
if you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of
Really.
course, Judge.
So,
Thank you.
but until that time, don't pick up a new case. Don't go back. All right, so Vic, you want to give me a date?
Yes, Judge, how is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work.
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. Okay?
Go ahead and save her behind you.
Okay. Signed. You are Jonathan Caldwell. Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. You understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. You too.
Judge, are there going to be state's bond conditions?
No, I'm not putting any conditions, just the no driving affidavit.
House is approaching on page 2. Barnes.
Mr. Pruitt,
Hello, Judge.
happy Friday, man.
The one you, Ron Barnby was in jail in Fort County.
Oh, we reinstated, okay.
Here today because you wanted to bond conditions.
Good morning, Mr. Barnes.
Good morning. Sir Davis, sir.
Go ahead.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave, don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The case is still open in Fort Bend. It's still pending. Your next court date is down there. It's on March. Not all the cases are open. One of them still open. Paul Two's representing him. I talked to Paul yesterday. And it's set for sometime in March. I can't recall the exact
It's
date.
okay. Have we done PC on this yet or no?
We haven't done anything because he was in custody.
Right, okay, so we're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex,
Yes,
please.
Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
Your Honor, the only thing would be officer safety, just the pat down. That.
All right, Mr. Barnes, I'm gonna find no probable cause. Just be careful, all right? Really, you hang with dogs, what happens? No. Well, you get fleet. Well, you can get bit too, right? Please.
Because a bad dog.
Just don't hang out with the wrong people, all right? Come on. We really have 4 open cases now with Miss Newton? What is your true name, ma'am? Miss Newton, you now stand charged with 2 more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An AFIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items is $268.
She has a theft from December of 22, a theft from June of last year, and now 2 more cases. Was she on bond for either of these cases when she picked up the 2 new cases?
Let me see, Your Honor.
You are looking at Miss Newton here. Was she on bond for any of these cases, or were they all just in open status? It's 254. 8009.
It appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
In the court processing page, last name KOTUN, that's the original case, and there were multiple bonds posted on that one. A GOP and a surety, and then these other cases got picked up. So it's a 3rd name.
On the 251, it appears she posted bond only one time on the 19th of this month. On the 243.
Yes, Judge, on the 243.
That's the one that was
the
in
GOP
current status, right?
Yes, Judge.
Where are all those from?
So the theft, cause number 243 was a Dick's Sporting Good.
So Dick's,
and then 251 theft was a Sephora, and then the most recent theft was a JCPenney.
Miss Newton, Miss Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney, any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a fifth case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Morning, Mr. Price. Sir, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant Terrell and the defendant were in a previous dating relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat, but did not impede breath. The defendant would not allow the complainant to leave, and complainant Asher, friends with complainant Terrell, walked into the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a?
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? On the family member case, I'm not seeing a protective order issued on Price. You see one?
I don't see one final.
Okay, I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You'll need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box while we get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. Please.
This way.
You are Jamarcus Randolph. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. Can you look up to see if he has a...
It's not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show to me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. Show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on.
Jim, we're not done with the rain.
Good morning, sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. So this is the one that we were talking about the other day, right? Where it looks like initially a magistrate found no PC, right? But then we have a refile the next day. Will you go ahead and read PC? You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer met with a complainant who stated that the defendant is her ex-husband, and the complainant advised that on August 25th, 2024, the defendant was at her residence regarding a visitation. As the two children went into the home, the complainant told the defendant to leave. The defendant then pushed his way into the home and pushed the complainant against a wall, causing pain. The officer observed surveillance footage showing the defendant push and strike the complainant in the upper chest area.
Oh, there's a strike.
Yes, Judge.
Okay. Mr. Reichert, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. Get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You're not to have contact with this person and not to go where she lives or where she works. Do you understand? No, I can give you a lawyer.
Sir?
I can give you a lawyer if you'd like.
Yes, sir.
Talk to the lawyer and the lawyer can come up and talk to me. I just don't want you to say anything. Believe it or not, I'm trying to help you because I've got a bunch of DAs here. Whatever you say, they're going to try to use it against you. All right. Do you need a lawyer?
Yes, sir.
All right. I'm going to have you sign a receipt of Victoria. We'll have you skip in the jury box. If you can file the conditions, no contact, no weapons, please.
Yes, Judge.
Have you signed the conditions, and then we'll provide your lawyer here momentarily. Okay? Please, sir.
You need this, Judge?
No, I have one on file. Thanks. For certain cases, they go in front of the magistrate, they'll already fill one out. So that's why I have it already.
Time for your reset. All right, Judge. Oh, next is page 27, Rocio.
Morning, Ms. Rocio.
How you doing?
Ma'am, you're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Hold on. We have a co-defendant here.
I mean, I don't know if it's the one we already have on docket.
Do you have a cause number on the
Yes,
co-defendant?
Judge. 1 moment, it's loading. Okay, whenever you're ready. The cause number for Smoots is 2523672.
Okay, yes, Judge, he's on the jail docket.
So we have it?
Yes, I think he's on for the 27th.
So he's still in custody?
Yes, Judge, he has felony today. So we're getting him Monday.
Oof. All right, Ms. Rocio, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On August 9th, 2024, the officer observed a silver Nissan with an expired registration and a traffic stop was initiated. The officer observed a strong odor of marijuana from the vehicle and observed marijuana in the back seat in plain view. A PC search was conducted and the driver, Mr. Smoots, was detained. The female passenger began to act very irate and yelled at the officer. The officers told her to back up and stop interfering multiple times, and she refused multiple commands. The officer attempted to place her into handcuffs, and she began to walk away and pull away from officers. The officer had to assist her to the ground, and she was identified with her driver's license.
Ms. Rocio, I'm going to find that there's probable cause to go forward with your case. The only condition I'm placing on you is not to have contact with the co-defendant in this case. You understand? Sorry? Do you have a lawyer? Do you want a lawyer? Okay, we can provide you one today, but talk to the lawyer. The lawyer can answer any questions that you have. I don't want to answer anything now because whatever you say, they can use it against you. Just the only thing I'm asking you to do is don't pick up any new cases. Don't have contact with the co-defendant in this case. Mr. Smoots, do you understand? All right, can you file those conditions for me,
Yes, Judge.
please? We'll have you sign a receipt, Victoria, and then we'll have you take your seat in the jury box. We'll get all the documents ready for you.
Right this way. Next judge is page 29. Where? Come on up. Come on.
You're a Kiana Ware. Miss Ware, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 19th, 2025, the officer was dispatched to a two-motor vehicle accident on the 1900 block of Southwest Freeway. The officer observed the defendant's vehicle with damage to the front right side, and the officer made contact with the defendant, who was observed to have a strong odor of an alcoholic beverage, slurred speech, bloodshot, glossy eyes, and poor balance. The defendant stated she was coming from a friend's house, was driving home, and had drank 7 glasses of wine. The officer observed the defendant to be emotional and have changes in mood, and a witness, the other vehicle involved in the collision, observed the defendant in the driver's seat. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and refused to provide breath. A blood search warrant was signed and executed.
Are DWIs? Can you
No,
run?
Your Honor. And
Under
eligible
NCIC?
driver's license.
Have you run our NCIC?
Yes, Judge, and there's no prior DWIs.
Right, ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I'm going to revoke your bond, put you in jail. You understand, ma'am? Okay. Did you need a lawyer today, ma'am? Okay, we will provide one to you. I need you to fill out an application for me, and then I'll have you speak to someone. Don't use. That's all I'm asking you to do. Don't pick up any new cases. Don't be a danger to my public. Do you understand, ma'am? Okay, come on.
This way.
Ms. Williams, ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 13th, 2025, the officer was dispatched to a disturbance regarding a female in a motor vehicle on Westheimer Road. The officer observed the defendant stopped in the parking lot of a gas station and the officer observed the defendant exit the vehicle from the driver's side while holding her keys. The first and second complainant had previously seen the defendant driving between 2 gas pumps, hitting a trash can before stopping in the parking lot. The defendant proceeded to walk towards the officers, who observed the defendant swaying side to side, observed bloodshot, glassy eyes, observed poor balance, and a strong odor of an alcoholic beverage. The officers then detained the defendant and performed standard field sobriety test, HGN 4 out of 6, walk and turn 7 out of 8, and one leg stand 3 out of 4. The defendant was read the DIC and agreed to provide a specimen of blood.
Okay, any priority to be ice?
No, Your Honor.
And I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. Do you understand, man? Did you say she has a valid Texas driver license?
I'm running it right now, Your Honor. It's eligible, Your Honor.
Okay, you can drive as long as you have a license and liability insurance. If you don't, do not drive. Do you understand? Do you need help with a lawyer today, man? Do you want one? You need one. Okay, I'll provide your lawyer today, but so for now, I'll have you sign a wreath, Victoria. You will have to meet with Fleischer of your bond conditions. For now, we'll have you take a seat in the jury box while we find your lawyer. Okay? Please.
Right this way. Go ahead and sign for your list. All right, Judge, next is page 41.
Mr. Lestrep, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 16, 2024, officers were dispatched to a Walgreens in Harris County, Texas. The officer spoke.
Same Walgreens as always?
Yes, Judge, it is. And the officer spoke with the complainant, the store manager, who stated she knows the defendant by sight and name. The complainant was able to identify the defendant and stated the defendant is a habitual shoplifter at the location. The defendant has a trespass warning from January 24th, 2024. And on the 17th of January 2024, the defendant stole a total of $145.81 in merchandise. On the 24th of January, the defendant stole $100.71 worth of merchandise. And on July 17th, 2024, the defendant stole $105.80 worth of merchandise. On August 1st, 2024, the defendant stole $43 worth of merchandise. And on August 15th, the defendant stole $70 worth of beer. On September 16th, the defendant stole $70.49 worth of merchandise. On November 30th, 2024, the officer stole $30.25 worth of beer. The total value for all thefts was $506.86. Let's
go out of jail.
Mr. Lestrep, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to go back to this Walgreens. I'm putting an ankle monitor on you right now. If I find that you violate this, you go within 1,000 feet of this store, I'm going to revoke your bond. I'm going to put you in jail. No more PR bonds. Do you understand, sir? 1,000 feet, you're not to go within this Walgreens. Do you understand?
Yeah.
I will provide you a lawyer today, Mr. Lestrap, but I'm done. This is it. Right, you mind reaching out to the mag for Mr. Lestrap, please? Okay, I'm going to have you sign a reset. You'll get with Fleischer for your bond conditions, and then I'll have you talk to a lawyer here momentarily, Mr. Lestrap. Mr. Hayes, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Actually, you're charged with 2 counts of assault. You're facing up to a year in jail and or a $4,000 fine. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On June 3rd, 2024, the officers were dispatched to an aggravated assault call, and the officers met with 2 complainants. The first complainant was in a prior dating relationship with the defendant. The second complainant is the first complainant's mother. The first complainant stated the defendant and her were at a party when the defendant started to become upset, and the first complainant was not responding to his advances. The 2 got into a verbal altercation, and during the verbal argument, the defendant punched the first complainant in the face several times, causing pain. The second complainant stated she observed that the defendant and the first complainant were in a verbal argument and went over to intervene, but was struck in the face with a closed fist by the defendant, causing pain. The defendant then left and returned with more family members, and the first complainant stated the defendant continued to assault her until gunshots were heard and the defendant fled.
Hey, stop.
I'm sorry.
Do we know if alcohol played a part in any of this?
There are no allegations of alcohol, Your Honor.
Mr. Hayes, I'm going to find that there's probable cause to go forward on both of your cases. In both of your cases, protective orders have been issued. I would get to know them. If you violate the protective order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? I am ordering you not to have any contact with either of these people at all throughout the duration of this case and not to be in possession of any weapons. I'm going to do everything in my power to protect my public at all costs. Be aware of that. If I find that you pick up a new case, you endanger my public, I will revoke the bond, put you in jail, and I'm going to make them extremely high. You have a lawyer. I don't know where your lawyer is, but because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with the lawyer. If the lawyer tells me he can't get hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest.
Okay.
For now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then we'll just wait for your lawyer to get here, sir.
And my lawyer's gonna be coming here.
I don't know. He's not here yet, so hopefully he shows up. Like you were charged with driving while intoxicated, second offense. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Give the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge. On January 18th, 2025, The officer observed the defendant's vehicle stopped and impeding the moving lane of traffic, with other vehicles having to honk and go around on the 2300 block of Bagby Street. The officer honked and used sirens multiple times to get the driver's attention, but the defendant chose to ignore him even after the passenger advised the defendant that the officer was attempting to get her attention. A traffic stop was then conducted, and the officer observed slurred speech, glossy eyes, and a strong odor of alcoholic beverage. The defendant admitted she drank 2 beers while at a memorial in downtown area, and the officer had the defendant exit the vehicle and observed unsteadiness on her feet. The defendant refused to answer anything else and was uncooperative on the scene. At JPC, center field sobriety tests were conducted. HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed.
And I'm going to find that there's probable cause to go forward with your case. You have a valid Texas driver license.
It's eligible, Your Honor.
I am now placing a restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail because I will revoke your bond. You're also not to consume,
Whitaker, or step outside and talk.
not to consume alcohol, illegal drugs, or unprescribed controlled medication, and I'm going to randomly test you. If I find that you're using, likewise, you will go to jail, ma'am. I'm sending information to DPS so that every single officer in this state will know if you get pulled over, they will know that you're to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they will take you to jail. Do you understand, ma'am? Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer, ma'am? Sorry? You're going to hire a lawyer. Okay. So what we'll do now is I'm going to have you sign a receipt with Victoria. We'll have you meet with Fleischer for your bond conditions. After that, we'll get you out of here. And then when you come back, please have a lawyer. Okay.
Right this way.
You are Eziel Martinez Antonio. Sir, you are charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge. On January 19th, 2025, the officer was dispatched to an accident on TC Jester Boulevard. The officer found the defendant in the driver's seat of the vehicle, and the officer observed bloodshot eyes, and upon exiting the vehicle, the officer observed the defendant to be unsteady on his feet. The officer spoke with the complainant, who had seen the defendant stopped in her lane of travel with hazards on, and after waiting through several green lights, the complainant attempted to go around the defendant and take a right turn in front of the defendant, who drove forward, causing his front end to collide with her vehicle. The defendant continued forward, pushing the complainant into the intersection. The complainant observed the defendant never left the vehicle before officers arrived. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 4 out of 4. The defendant read the DIC and consented to breath. The results were 0.177 and 0.172.
Run an NCIC, please. And
Yes, Judge.
see if he has a valid license, please. Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it on a daily basis, they will put an immigration detainer on you. You will be stuck in custody until this case is over with and then shipped off to immigration.
There's no prior DWIs and there's no license on file.
If you do not have a Texas driver license and liability insurance, you are not allowed to drive. That is also a condition of your bond as well. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what's going on in your life. If you do not have a Texas driver license and liability insurance, do not drive. Do you understand?
Yes.
Gibson?
Did you need a lawyer today, Mr. Martinez?
I'm gonna hire them.
Okay. So what we will do is I will have you come up here, swear to us that you're not going to drive until you have both documents. Please
I swear.
take heed because I take this absolutely serious. Same with no consumption of alcohol or illegal drugs. After this, I will have you sign a receipt with Victoria. After you sign the receipt with Victoria, you will meet with Felicia for your bond conditions. After that, you will be free to go. Do not pick up any new cases. Don't be a danger to my community. Otherwise, I only have one place for you.
All right, Judge, this is Martinez.
You are Christian Martinez. Mr. Martinez, you're charged with reckless driving. You are facing up to 30 days and or a $500 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officer in an undercover capacity observed the movements and actions of a takeover group at a parking lot on West 20th Street. The officer radioed to other units about multiple motor vehicles doing donuts in the parking lot filled with spectators inside their vehicles. During the takeover, there were approximately 80 to 100 motor vehicles in the parking lot, and the officer observed the defendant's vehicle do 4 to 5 donuts within 10 to 15 feet of other vehicles, as well as plainclothes officers. A traffic stop was conducted, and the officer made contact with the defendant, the driver of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Do you have, you see if he has a valid Texas driver
No
license?
license on file.
If you do not have a valid Texas driver license and liability insurance, Mr. Martinez, you are not allowed to drive. That is a condition of your bond. I don't care what's going on in your life. You will be signing a promise with me today that you're not going to drive. If I find that you do, I'm going to revoke your bond. I'm going to put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it on a daily basis, they will put an immigration detainer on you and you will be stuck in there until this case is over with and then shipped off to immigration. Appointed lawyer, or do you have the ability to hire a lawyer, Mr. Martinez?
I'm good hiring a attorney.
Okay, I will have you come up here, swear to us. After that, I'm going to get you to Victoria where you will sign a reset and then we're going to get you out of here. I'm going to protect my city at all costs, Mr. Martinez. Take that into account, whatever you're doing out there in the free world. Good luck, sir.
1 minute, I'm almost done.
You are Raul Chavez. Mr. Chavez, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 15th, 2025, officers are dispatched to a family disturbance. Officers were dispatched to a family disturbance, and upon arrival, the officers met with the complainant, who stated that she and the defendant started arguing over the defendant, accusing the complainant of cheating on him. The defendant stated that the defendant grabbed the complainant by her hair and pulled her to the ground, causing pain. The defendant then wrapped his arms around her neck and later struck the complainant several times in the stomach. The defendant admitted to wrapping his arms around the complainant's neck for approximately 3 seconds.
Mr. Chavez, I'm going to find that there's probable cause to go forward with the case.
Here you go.
It looks like a protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can, possibly will file a violation of a protective order against you. It's one of the worst cases you can pick up. I am ordering you also not to have any contact with this person and not to be in possession of weapons. If you violate this, I will put you in jail by revoking your bond. Do you understand? Can you file no contact and no weapons, please, Alex? Did you need a court-appointed lawyer, Mr. Chavez?
I thought I did have one. I already spoke to someone. I think his last name was Torres.
You don't have a court-appointed lawyer. Do you want one?
Spoke with
Though?
him when I was in jail, when I was in jail.
It's just,
That was for magistration purposes only.
I do need one.
Okay, we'll appoint your lawyer today. I've got an affidavit already on file. All right, just take a seat for me. Do not leave until you sign our bond conditions and then after you've spoken to a lawyer. Okay? Take a seat.
right this way.
Oh, wait. No, he needs to sign a reset first. Mr. Carell, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 18th, 2024, officers were dispatched to a family assault and made contact with the complainant, who stated that she and the defendant are dating. The complainant stated that they got into an argument when the defendant grabbed the complainant's arm and squeezed, causing pain. Complainant stated she punched and struck the defendant to get away. The complainant stated that the day prior they had gotten into an argument and the defendant grabbed her by the arm and squeezed while the complainant fought to get away. The officer observed bruises on the complainant's arm.
Got it. Mr. Carell, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate these conditions, I'm going to put you in jail by revoking your bond. Do you understand? I don't see a protective order that's been issued. Has one been issued in this case?
I see it as of 10/19, Judge.
No, but it's not been signed. Carell. Yeah. Do you guys see it or no?
That's
All right, Mr. Carell, I'm entering in what's called a mattress order of emergency protection that identifies Ms. Cabrera as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the East Tex Freeway Apartment 4304. If you violate this court order, the state can and will file additional charges against you, including a violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do before you leave this place. Do you need a court-appointed lawyer, Mr. Carell? Okay, I'll appoint your lawyer today. Do not leave until you sign all our bond conditions. Otherwise, a warrant will issue. Please.
You don't do it, Santos. No.
You are Miss Delgado Ortiz.
Yes.
Ma'am, you are charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 12th, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. The officer made contact with the complainant, who stated that he and the defendant had been dating for 8 months. The defendant is about 5 months pregnant with their child, that he and the defendant got into an argument earlier that day, and that he left to go speak with his sister because he was contemplating breaking up with the defendant. The complainant stated when he went back to the residence to grab items, the defendant began arguing with him again. The defendant told him she was going to break his TVs. The complainant began recording. The defendant threw Xbox headphones and threw them at the complainant, hitting the complainant in the right hand, causing pain. The defendant then approached the complainant, tried to grab the cell phone out of the complainant's hands, grabbed the complainant's hair on the right side with one of her hands, and pulled, causing pain. The defendant stated she and the complainant got into an argument over money, and the complainant threw her clothes on the ground. She got upset, threw the headphones on the ground, but that she did not throw the headphones at the complainant. The defendant further stated she got upset because the complainant was recording her. She attempted to grab the phone, and the complainant grabbed her hair and pulled, so she grabbed his hair and pulled. The complainant then attempted to throw her on the ground, and she hit the floor, causing pain.
Ms. Delgado, I'm going to find there's enough probable cause to go forward with your case. A protective order has been issued in this case, and I would get to know it. If you violate the protective order, the state can and will file additional charges against you. I am ordering you not to have any contact with this person and not to be in possession of any weapons. I don't know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in there until this case is over with and then shipped off to immigration. Do you need a court-appointed lawyer today, ma'am?
Yes.
I will appoint your lawyer, but I'm telling you now, do not pick up any new cases. Do not violate any of these conditions. Otherwise, I'm going to put you in custody. Do you understand?
Yes.
Okay. Do you mind filing those conditions, Alex, please? Okay. For now, I will have you sign a reset with Victoria, and then we will have you take a seat in the jury box while we find your lawyer. So, Mr. Jones, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. On the assault case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Which case, Your Honor?
Both. We have to do both. Dealer's choice.
Yes, Judge. So on the 8th of M on June 24th, 2024, officers were dispatched to a disturbance. The complainant and the defendant were in a verbal argument over his driving, and the defendant continuously made threatening remarks to the complainant until they arrived at their apartment. The complainant locked herself in her bedroom, and the defendant kicked in the door. The complainant tried to flee the apartment, and the defendant grabbed a kitchen table chair, lifted it above his head, and slammed it on the complainant's head, causing pain.
Gosh.
The officers observed the complainant had open wounds on her right pinky finger, the inside of her right forearm, and her upper neck chin area. And then on the DWI, on January 18th, 2025, the officer was dispatched to a traffic hazard on Airport Boulevard in Harris County, Texas. The officer met with a wheel witness who said he was driving when he saw a truck that was stopped and turning off in a moving lane. The wheel witness went to the truck and saw empty beer cans in the bed and the defendant in the driver's seat. The wheel witness said the defendant appeared to be intoxicated, so he called police. The officers made contact with the defendant and noticed an odor of an alcoholic beverage, watery red bloodshot eyes, and slurred speech. The officer asked the defendant to step out of the truck and noticed the defendant was swaying. The defendant said he was coming from his mom's house and had two 12-ounce beers prior to driving. The defendant refused to participate in center-field sobriety tests. The defendant was read the DIC and refused to provide a sample. A blood search warrant was signed and executed.
Is there alcohol in the car while he's driving?
No, Your Honor.
And Judge, if you look at his eyes now, his eyes are red. I think that that's more of a medical condition than anything.
As far as the assault is concerned, he had an assault that was dismissed in 23. Is this the same complaining witness, Alex?
Yes, Judge.
Mr. Jones, there's a protective order that has been issued in this case. I would get to know it. If you violate said protective order, the state canon will probably file a violation of protective order. That is the capital murder of misdemeanors. Do you understand? It's one of the worst cases that you can pick up. I am ordering you as a condition of your bond not to have any contact with this person whatsoever, not to be in possession of any weapons. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, can you run a full NCIC, please? And does he
Yes,
have
Judge.
an-
And
does he
there's no prior DWIs.
Texas driver license?
Yeah, I'll run that right now, Your Honor.
Please.
Your Honor, the driver's license says eligible in our system.
Okay. Like I said, you're not to have any contact with the complaining witness in this case. I don't care if she calls you. You have contact with this person, then I'm going to put you in jail. If she calls you, do not answer the phone. If she calls you from an unknown number, you hang up the phone. If she texts you, do not reply. If she comes to your house or wherever you may live, don't answer the door. But if I find that you have any contact with this person, it's just not going to go well for you. I've given you a lawyer. It is your responsibility to stay in touch with Mr. Prez. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, likewise, a warrant will issue for your arrest. I'm going to do everything in my power to protect this community in every single way. Do you understand? Okay. All right.
Thank you, Judge.
Goes with you.